So I want to just sort of walk through the history of the right of privacy under the federal Constitution to explain how we got to Dobbs, which was, by the way, in no way a surprise that the court did that in Dobbs. And then also talk about the right to privacy in Montana, because it's different in Montana, because unlike the federal Constitution, which does not have an explicit right of privacy, our Montana Constitution does. And that makes all the difference. It might not save the day, but it makes a huge difference to the discussion of the right of privacy and abortion in Montana. Let's see here. Let me see. Okay. Oh, come on. Okay. Sorry, now this is being connected here has kind of messed this up, so it's not working. There we go. Okay. Thank you. So this is just briefly the outline of what I want to talk about. The history of the constitutional right to privacy, what Dobbs actually decided, the implications for the future of other privacy rights under the US Constitution, the right of privacy in Montana, and the current state of abortion in Montana. If we have time, which I suspect we won't, we could talk about LR 131, the Born Alive Infant Protection Act, which is on the ballot, if you'd like to talk about that, because that is related to both. Well, it claims to be related to abortion, and I think it is related to privacy. So I don't know, we're supposed to be done at 1. If you're a student in my class, you know we're never done early. I'm happy to stay later if we have the room later, and we can continue talking about whatever's of interest to you. So to understand what Dobbs did and understand how we got to Dobbs, the first important thing I think is to understand basically roughly 2 schools of constitutional interpretation. So 2 schools of constitutional interpretation, and this is what has really been an issue ever since the court in 1965 found that there's a right, an explicit right, found explicitly that there's a right of privacy in the Constitution. So the originalist school basically says that you should look at the text of the Constitution. And if that tells you to whether a certain right is there or not, we're done. Like due process, clearly in the Constitution, obviously it's there. If it's not obvious, then you look at what was intended at the time the constitutional provision was written. So that would be 1790. Well, it was ratified in 1792 for the main part of the Constitution and the Bill of Rights. 1868 for the 13th, 14th, 15th Amendments, later for later amendments. The key one we're going to be talking about today is the 14th Amendment, which was passed and ratified in 1868. So the originalists would say that you need to look at the text, and if the text is clear, you're done. If the text is not clear, then you look at the intent at the time the provision was adopted. The reason for this approach is that the originalists say it's not the job of courts to make up new rights in the Constitution. The Constitution is what guides our courts in what rights are so fundamental that they're protected by the Constitution and which are not in the Constitution. And the Constitution belongs to the people. They say, the originalists say, it's not for the courts to make up new rights. So the right of privacy, for example, is not in the Constitution. That word is not in the Constitution. And so what the court starting in 1965 did was, and I'll get to that in a minute, but basically what they did was say, well, it's implied in the Constitution because of all these other provisions. The originalists say that's illegitimate. Because if you allow justices to do that, then there are no guardrails on what justices can make up and just kind of put in the Constitution because that's what they want to be in there. So the idea of the originalists is, in order to ensure that courts interpret the law rather than make the law, there have to be some guardrails on the justices, and those guardrails are the Constitution, interpreted as it was intended at the time the particular provision was written and approved. If you want to add, if we want to add more rights into the Constitution, great, we can do it through the amendment process. It was written for that. That's in the Constitution, with the expectation that rights might change. The people might want to add or maybe take away rights that are in the Constitution. We have a process for that. It's called the amendment process, not judges. It's the amendments. That's how you do it. The other interpretation is more the living constitutional school, which says the Constitution was always intended to evolve along with our social rights. It was never intended to be static. It was never intended only to protect the rights in 1792 or 1868. That isn't how it was designed to be. New rights are necessary to fulfill the vision of the Constitution. So as we evolve, we discover that that rights are important to liberty and freedom that maybe weren't recognized at the time. And the whole point of our Constitution is to ensure that we have the liberty we need to be complete human beings in our democracy. The problem with the amendment process, the living constitutional school says, is that it depends entirely on the majority. Because to amend the Constitution, you have to have 2/3 of both houses, both the Senate and the House, and then you have to have a majority of the states approve it. And that's majority rules. But the whole point of the courts is to protect minority rights. Not the whole point. One of the important points of a court is to protect minority rights. And this is a conundrum and a tension within our democracy and within our Constitution, that mostly majority rights win, but there are rights that are so fundamental to liberty that they can't be left to the majority, because then the majority could run roughshod over those people's rights. Slaves in the 1860s, for example. I would add women to that. And so that is the problem with the amendment process. Yes, the amendment process is there, but it's going to reflect the majority. It's not going to protect the minority. So these are two different ways to interpret the Constitution. And importantly, a lot of the underlying question is about who gets to decide what rights we have. Is it the majority of the people, or is it the courts protecting the minority? And there are very good, strong, legitimate arguments on both sides of that. And that's what we see in the history of privacy under the US Constitution, including in Dobbs. So if you remember this, and I'll keep referring to this, but you'll see how this plays out in these cases. So to get to the right of privacy, there were some cases from the Supreme Court in the early 1900s that alluded to privacy, but didn't fully bake the concept. So for our purposes, I want to start in 1965 with Griswold versus Connecticut. This is a case where Connecticut had an old statute dating back to 1890 something or other that prohibited the use of contraceptions and prohibited supplying people with contraceptives. It dated way back by the 1960s. Nobody was paying any attention to this law, but it was still on the books. And so Planned Parenthood of Connecticut sued to have it removed from the books. And that case went all the way up to the US Supreme Court. So in that case, the majority found by a 7-2 decision that there is a constitutional right for married couples to use contraceptives. And they found that by saying, well, okay, so the Constitution doesn't actually say privacy. But the concept of privacy is embedded in the Bill of Rights. In the First Amendment, right of freedom of religion, freedom of assembly, freedom of speech, these all imply the importance of privacy. The Third Amendment does not allow the housing of troops in individual homes, privacy. Fourth Amendment, due process in search and seizure. Your home is protected from just random searches by the government. That's privacy. Fifth Amendment, your right to not incriminate yourself. So the court pointed to the Bill of Rights and said, and this third bullet is just has been quoted over and over with a great deal of derision, I have to say, by many people. Specific guarantees in the Bill of Rights, the amendments that I just mentioned, first, third, fourth, fifth, have penumbras formed by emanations from those guarantees that help give them life and substance. So the idea is that, okay, so the Constitution doesn't say privacy, but it's obviously implied in all of this. And we can't have true liberty from the government, freedom from government interference, unless we have privacy. So it's a penumbra and an emanation in there. And based on that, one of the most fundamental rights is the right of marital relations. That is one of the most private rights we have, that you can marry who you want and you can do what you want in the privacy of your own home with your partner. That implies that you also have a right to decide your procreation, which implies that you have a right to contraceptives for married couples. It was only for married couples at the time. And later, by the way, over the next 15 years ago, the court had additional cases that found that there's a right to contraceptives for unmarried couples and for minors 16 and over. That was a really controversial one, but the loop was closed. So this case was only about married couples, but eventually it covered everybody over 16. So the dissenters said, this is ridiculous. There's no right of privacy in the Constitution. So they're the originalists. The dissenters said, that is not in the Constitution. It's not in the text. The right to contraceptives was certainly not something that everybody thought that the Bill of Rights covered in 1791. I mean, that's just ridiculous. It's not there. So they said, if you want it there, amend the Constitution, but it's not there. So here we have the originalists saying it's not there, and the living constitutionalists say, yeah, but it's implied and it's necessary, and the Constitution has to evolve as we discover various aspects of privacy that maybe people in 1791 didn't think of. And by the way, just as an aside, think about who got to vote in 1791, white men with property. So of course it wasn't there. Yeah. A penumbra. So in my bio, so I'm the classics major, so I love this. You know, my students roll their eyes when I talk about Latin and Greek, but penumbra is from Paine, which means almost. Umbra means shadow. So it's like this shadow around the right not to house troops in your house. It says that, but the shadow around it, the bigger context is protecting the privacy of your home. So the penumbra is this sort of shadow that's associated, yes. Which is why that sentence has been made fun of ever since, saying it doesn't mean anything. This is ridiculous. But that's what the court decided in 1965. 2 years later, we got Loving versus Virginia, which many of you may remember. You may have seen the recent movie about it, which was actually a 9-0 decision. This was Virginia had a law that said that prohibited interracial marriage. And the court found it unconstitutional, not based on the emanations and penumbras in the Bill of Rights, but based on the 14th Amendment, equal protection clause and the due process clause. So it was a 9-0 decision in part because it was not hard to say that a law that prohibits interracial marriage is based on race. That violates the equal protection that everybody has regardless of race. Therefore, it's unconstitutional and violates the 14th Amendment. The second part of Loving, however, referred to the due process clause, which you can see over on the right there. So it says, no state shall deny to any person within its jurisdiction, oh, that's equal protection. No state shall deprive any person of liberty without due process of law. That is really important for the right of privacy, because in Loving, the court said that the freedom, the liberty to marry is fundamental to this right of liberty in the 14th Amendment. And therefore, the court said, because of the 14th Amendment without due process of law provision, you can't prohibit people from marrying who they wish, because that's a fundamental liberty protected by the 14th Amendment. So in Loving, the court found it on both strands, both equal protection and the liberty/due process clause. Loving did not mention privacy, and it did not mention Griswold, but it was clearly implying a right to privacy of marital relations. That was a 9-0 decision, so there was no dissent. And I think that's in part because the equal protection part of the decision was pretty easy. You could have decided on that without going to the liberty/due process clause. Then in 1973, we get Roe versus Wade, which really brought together the Griswold privacy and the Loving 14th Amendment into a right of privacy in the Constitution. So in Roe versus Wade, there was a Texas law that prohibited abortion except to save the mother's life. And the court, by a 7-2 decision, decided that that violated the due process clause of the 14th Amendment. So the court essentially combined the Griswold finding of a right to privacy in the penumbras and emanations of the Bill of Rights, but placed it in the 14th Amendment as Loving had essentially implied. So the court admitted, as you see here, that the Constitution doesn't explicitly mention a right of privacy, but says that we have a long line of cases that find that there are fundamental rights that are protected in a so-called zone of privacy, is what the court called it. And that basically implied going way back and say, okay, in the history of our nation, what rights have we found to be necessary? And they include the marital right, the right to supervise your child's upbringing and education, and a few other rights. But the court said, realized that they were in danger here of making up rights, of saying, well, the 14th Amendment due process clause doesn't mention privacy, it doesn't mention specific rights, so we better be a little bit careful about what rights we find implied in the Constitution. And the way the majority in Roe versus Wade limited that was this third bullet: only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are included in this guarantee of personal privacy. So the question, well, what are fundamental rights? And the court in Roe did not define what fundamental rights are, but they identified them as, based on previous cases, including Griswold and Loving, marriage, procreation, contraception, now abortion, family relationships, child rearing, and education. So that's how we got to Roe versus Wade. But Roe versus Wade was deeply controversial because it made up this right of privacy. Well, for two reasons. It also basically made up the trimester test of when an abortion could be regulated or made illegal. So the court made up what you can do pre-viability, and that was a lot of people say that was the court legislating. That wasn't based on any law anywhere. That was the court saying, let's see, how could we figure out how to balance these rights of the mother and the fetus? And they came up with this trimester system that has been criticized for a long time. But Roe has also been criticized for explicitly finding a right of privacy in the 14th Amendment that was not explicitly there in the text and was not intended by the people who wrote and ratified the 14th Amendment. And so Justice Rehnquist, as one of the two dissenters, was very explicit about that. Here you see again this originalist approach to constitutional interpretation, saying that abortion is not a fundamental right because states forever have prohibited it. How can you say that something that state legislatures have prohibited until recently, until the 1960s, early 1970s, how can you say that's a fundamental right in the 14th Amendment? It's just, he says, that just doesn't match history. And he goes on to say, so the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment. So here again, you see this fight between the living constitutionalists who say there has to be privacy in order to have liberty, and privacy based on long precedent includes marriage, procreation, education, and so on. And if it includes marriage and procreation, then it has to include abortion. But you'll see that's multiple steps. What's the saying? If you have to explain, you're losing. Yeah, so you have to really explain in Roe how you got to this right of privacy, whereas for the dissent, it's pretty easy. It's not there, and it wasn't meant to be there. And we have seen that those dissenters consistently through subsequent privacy cases. So there are several more privacy cases. You may well remember these. There's Lawrence versus Texas, which found a constitutional right to engage in same-sex intimate sexual conduct among consensual adults. That the court found was constitutionally protected under the right of privacy that is implied in the 14th Amendment. And Obergefell versus Hodges, which is the gay marriage case, which said the same thing. We have a long history of finding that marriage is a fundamental right under the 14th Amendment. And so gay marriage is too. I mean, marriage is marriage. So the court found that in both of those cases. The dissenting judges continued to argue there's no right of privacy in the Constitution, or if there is a right of privacy, it is only for fundamental rights that are deeply rooted in our history and tradition. And they kept saying abortion isn't, gay marriage isn't, intimate same-sex conduct is not. None of those things, they said, are deeply rooted in our history and traditions, nor are they necessary for ordered liberty, which they didn't define. And so the dissenters consistently said the same thing that you then see in Dobbs, the majority. And notice also that Griswold back in 1965 was a 7-2 decision. Loving was 9-0. Roe was 7-2. The majorities are getting smaller and smaller, and the dissenters are getting more and more. So this is why I say Dobbs was in no way a surprise, because you could see the majorities shrinking and the dissenters waxing. And so when you get 3 new justices on the court, particularly when Ruth Bader Ginsburg is one of the ones who is replaced, it was pretty clear to see that the minority and the majority were about to flip. And that's what happened in Dobbs. So that's why I say that Dobbs really was not a surprise, because you'd seen it coming back from 1965. And by the way, the early cases, the contraceptives case, the interracial marriage case, Roe versus Wade, were all a product of the Warren Court, which was really a very activist court in the 60s and 70s, not only on personal rights, but also on free speech and several other issues. And so there's been really 50 years of pushback against the Warren Court, which had a very expansive reading of the Constitution. And even in back in the 60s, there were a lot of people, conservatives, who ultimately coalesced in the Federalist Society, who objected to that activist approach of the court. So Dobbs has really been the culmination of a 50-year effort to reverse the Warren Court. So the pendulum swings and it swings back and it just keeps going back and forth. It just takes a long time. I spoke to a group of 20 somethings about this the other day, and they were just shocked to realize that what they're experiencing now is the result of things that have happened over the last 50 years, well before they were born, sometimes before their parents were born. I'm such a nerd about this stuff. I was listening to Hamilton on the way here from Bozeman. I just love it. And I'm thinking, this is so appropriate. I'm listening to a musical about the creation of the Constitution when we're going to go talk about constitutional rights. History is still so alive. And, you're seeing the Lewis and Clark signs all the way across. I mean, history is still everywhere, and it all matters. So Dobbs, I want to just walk through a little bit what Dobbs ultimately decided, and none of what they decided now should be a surprise to you because you've seen it in these cases leading up to Dobbs. Mississippi passed a law that prohibited abortions after 15 weeks. So in other words, before viability. Viability is somewhere 21, 22 weeks. So Mississippi passed a law that prohibited abortions after 15 weeks. Clear and obvious violation of Roe versus Wade. It should have been tossed out. And it was, in fact, tossed out at both the district court level and the Court of Appeals, but it was designed to get to the US Supreme Court. And Mississippi got lucky because by the time it was ready for the Supreme Court, there was a new majority on the court. So it was the Mississippi legislature passed the law knowing that it violated Roe, knowing therefore that it violated the US Constitution, but it was a test case. And that's why it was that way. So the majority took the case and used it to overturn Roe versus Wade. They didn't have to. Justice Roberts in his concurrence agrees with finding that the Mississippi law is constitutional, but argued it was not necessarily to completely overturn Roe versus Wade. But the other 5 wanted to do that, and they did. So the basic outline here, again, of the majority is the Constitution doesn't say anything about abortion. Or the right of privacy, although in a minute we'll get there's some disagreement about what the Constitution says about the right of privacy. Abortion is not deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty. In other words, it's not a fundamental right. It's not one of those rights that Roe versus Wade referred to as the ones that are protected by this zone of privacy. Abortion is not a constitutional right, therefore. Instead, it's a moral question that should be decided by the people. And this is really important. It's been in the originalist school of thought for years, but it's important, I think, to pay attention to this because I have to say, superficially at least, and maybe not superficially, I'm very sympathetic to this notion that really hard questions should be decided by us, by we the people. That intuitively is appealing to me. I don't really want justices deciding these questions, particularly if they decide them in a way that I don't agree with. So there's a lot of appeal, I think, to thinking that, well, these really tough questions, we should hash these out in the political marketplace. We should talk to each other about it. We should, and this is what we're all doing now, of course, all around the country, including you, very importantly, the League of Women Voters is a really, really important part of this political discussion nationwide, including here in Montana. So there's some appeal to that. In a minute, I'll get to the issues with that. And the court said, because abortion is not a fundamental right, the state regulation of abortion is constitutional if the state has a rational reason for the regulation. And this is important and not reported typically because it's complex. It's legally complex. Those of you who know constitutional law know that there are different levels of scrutiny that the court applies to different rights, infringements of different rights. This is the lowest level of scrutiny. So the court basically says, because abortion is not a fundamental right, as long as the state has a reason for regulating abortion, it can. And the court went on to say such legitimate state interests that would justify regulation of abortion includes respect for and preservation of prenatal life at all stages of development. They said that's a legitimate state interest. At all stages of development. That implies to me that if a state legislature said life begins at conception, that would be a legitimate state interest and that would pass constitutional muster. A state court could do that. Other state interests include the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. So essentially, the majority gave state legislatures the recipe for how to regulate abortion. As long as you could point to one, preferably more, of those listed interests, you would be fine. The dissent, if you haven't read the dissenting opinion, I encourage you to. Of course, it's the losing side, but it's written in a very accessible and sometimes even humorous way. And I encourage you to read it. It's a good read. So the dissenters, and this too would be familiar to you because this is the Living Constitutionalist School. Constitutional interpretation can't be limited only to historical rights, because if you did that, it would be a static document that would only protect the people who had rights, in the case of the 14th Amendment, in 1868. And that includes none of us in this room. So that just can't be the way the Constitution is supposed to be interpreted, the dissenter said. They also go on to say that this notion that abortion is not deeply rooted in the nation's history and tradition, they say the court just doesn't have a complete history here. And one of the things that's interesting here is when the court in Dobbs and in other cases refers to deeply rooted in history and tradition, it's talking about legal history. So it's always referring to what was legal, what was not in the past. Well, who made those laws? White men. The dissenters are saying people have engaged in abortion always. And just because states prohibited it legally in laws written by white men doesn't mean that it isn't deeply rooted in our history and traditions. It just means it wasn't in the law. Lots of things that we all do is not reflected in the law. So they say this notion of the majority's interpretation of history is just not legitimate. And then this notion of implicit in the concept of ordered liberty, we didn't really know what that meant until Dobbs. And what the majority in Dobbs says is the concept of ordered liberty means that our system depends on balancing interests. And so a right that's necessary to balance interests may be a fundamental right. And what the majority said is that the dissenters and Roe did not balance interests, they prioritized the woman's rights. And the majority in Dobbs are simply saying, we're just bringing that back into balance. We're simply now saying, well, there's both a woman's right and a fetus right. And that's what we need to balance. And Roe didn't balance those. Roe didn't even consider the right of the fetus. What the dissent says is That's the whole point of Roe, is to balance those interests. That's why Roe created the trimester test, because up until a certain point, a woman's interest takes precedence. Then when the child is viable, now you have more of a balance of those interests. And toward the end, the viable fetus, that right trumps a woman's right. So the dissent said, it's exactly what we're doing. What the majority is doing is elevating the right of the fetus over the woman from day one, from the moment of conception. That's not ordered liberty. That's taking sides. So the dissent said, no, don't agree with that either. And because they say abortion is a fundamental right, it should only be regulated if the state has a compelling state interest. And this, for the lawyers, how many lawyers do we have in the audience? None. Okay. So this compelling state interest, this is a term of art that means that it's the highest level of scrutiny. And you have to have a really, really good argument to be able to regulate a right. You have to show a compelling state interest. And the interests that the majority lists as a legitimate state interest, the dissenters suggest none of them arise to a compelling state interest. So this is a really, really hard fought difference. And I encourage you to read these cases because, well, maybe I shouldn't actually, they're nasty. They're personal. I mean, they don't call each other out by name, but they all but do that. When Justice Alito says that Roe was egregiously wrong from the start, he's saying those 7 justices who were in the majority in Roe were idiots. I mean, that hurts. And that's personal. So this is, yeah, this is really, really an emotional argument on both sides. And it's not only about abortion, it's about what the Constitution says, who gets to decide what it says, and who gets to decide these hard questions. So now we know that we do not have a constitutional right to abortion. The question is, what's left of the right of privacy? Because the majority in Dobbs basically said abortion is not protected by the right of privacy. And the majority said, as it says here, nothing in Dobbs should be understood to cast doubt on precedents that do not concern abortion. So they're saying, we're going to touch contraception, marriage rights, same-sex sexual conduct, same-sex marriage. None of those are implicated by Dobbs because abortion in Dobbs includes 2 lives. None of those others do. All those other cases are about what you decide you want to do. Whereas in abortion, the fetus is a life that's equally valuable to the mother and has no voice. That makes it fundamentally different, the majority says. But Thomas, in his concurrence, and he's only one guy, but Thomas says, there's no right of privacy in the Constitution. You've heard that before, going back to 1965. He said, there's no right of privacy. Therefore, all those other cases are open to re-examination. The one he did not mention is Loving versus Virginia, the interracial marriage case. Yeah, so you're all thinking, oh, I know why that is. Another reason it might be is that you remember Loving was based on equal protection and not the right of privacy. Even though it is in the line of privacy cases, it was decided on different grounds. And that, if you want to really give Thomas the benefit of the doubt, you say that's why he didn't include it. There might be other reasons he didn't include it. The dissenting opinion says that's baloney. What you guys are saying, because you decide, they say the majority decided Dobbs based on the fact that abortion is not a fundamental right based on the right of privacy because it's not deeply rooted in our history and traditions. That's what the majority said. Guess what? Contraceptive isn't either. Same-sex sexual activity isn't either. Same-sex marriage isn't either. None of those are deeply rooted in our history and tradition. Therefore, they say either the majority doesn't believe its own argument, or those other rights are in fact under threat. And I don't see any other way to interpret it. The other thing is that Alito, who wrote the majority opinion in Obergefell, the same-sex marriage case, in his dissent wrote, there is no fundamental right to same-sex marriage in the Constitution. He's on the record having said that. Then in Dobbs, he said this case doesn't affect those other rights, but Alito already has said he doesn't believe there's a constitutional right to same-sex marriage. So we probably have at least 2 votes on the court to reconsider all of these privacy cases. So that's where we are. And that's a challenge. But I would expect us to see state. Okay, so I think that probably 3 or 4 of the justices now in the majority, on the conservative majority, they probably don't want a case on privacy. They don't want to have to reconsider contraception. And that's why they said Dobbs has nothing to do with these other rights. I don't think they want to go there. But I think we have a lot of unruly state legislatures around the country, including perhaps our own, who will be passing laws that say no same-sex marriage, no protection for same-sex sexual conduct, because it's the same strategy Mississippi used for abortion. You pass a law that violates what the Supreme Court has said about the Constitution. You lose, and then you appeal to the Supreme Court, and now you give the Supreme Court the opportunity to reverse their previous decisions. I think we're likely to see that. Now, the court can decide not to take those cases, and maybe that's what will happen. But I think we're going to see state legislatures trying to push the Supreme Court in that direction. So we've got a few minutes. We can talk about Montana, but are there questions, comments so far? I know this is a long journey. I can give you, I can send to Candace maybe a copy of the PowerPoint if you want it, so that you could go home and say, what was that again, as you're trying to explain this to someone. Oh, I got lost somewhere in the trail of breadcrumbs. So I can send this to you. Any questions on this so far? Yes.
Other cases. I've always known that thought of them as precedent.
Yes.
Is that what you are saying?
Yes. Yeah, so the question is, are these other cases precedents? Yes. So the way the legal system works is the court will base its decision today on what it decided before, unless it decides not to base it on what came before, and then it overturns those previous cases, which it did with Roe. And that was another half of Dobbs that we haven't even talked about, which is a big fight about when it's appropriate to overturn a precedent. And that's a significant part of both opinions, is a fight about that question. And that too is a very esoteric legal question. I guess why don't we hold that? If you want to stay later, I want to make sure we get to Montana, but I'd love to come back and talk, if you want to, about what the two sides, the majority and the dissenter, said about when it's appropriate to overturn. Yeah. So quickly, in Montana, there's good news and there's less good news, but let's focus on the good news first. We do have an express right of privacy in the Montana Constitution, and we have a Montana Supreme Court case that found that that right protects the right of abortion. So the Montana Constitution in Article 2, Section 10 says the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. There you have those magic words again. The compelling state interest says this is the highest possible right, and a state can only regulate it if it has a compelling state interest to do so, and that its method of regulation is as narrow as possible to accomplish its purpose. So that's very good, strong language. The downside is it doesn't explain what is covered. by this. And so the Montana Supreme Court has applied this to a variety of search and seizure cases, criminal search and seizure cases. Makes perfect sense. That's very much in line with the federal constitution. It also in 1997 decided that the right of privacy in the Constitution applied to same-sex sexual relations among consenting adults, which the U.S. Supreme Court also decided. What's interesting is the Montana Supreme Court decided that in 1997. The U.S. Supreme Court didn't decide it till 2003. And in fact, when the U.S. Supreme Court decided it in 2003, it actually overruled its own decision from 1986. Some of you might remember Bowers versus Hardwick, in which the U.S. Supreme Court in 1986 found there's no constitutional right to same-sex sexual intimacy between consenting adults. They said that's not protected by the right to privacy. In 2003, the court reversed itself and said, yeah, no, there is. But the Montana Supreme Court found that back in 1997. So that's pretty awesome. And then in 1999, the court decided Armstrong versus state of Montana. In Armstrong, the Montana legislature had passed an act that restricted who could conduct an abortion. So only doctors could do it, not physicians' assistants and not others. And that came up to the Supreme Court, and the Montana Supreme Court decided in Armstrong that the right of privacy in our Constitution includes the right to an abortion. And so that's a strong precedent. I think what's particularly important about the Armstrong case is that while it cited Roe throughout, it largely based the decision based on a medical right of privacy. And what's really important about that is that there's a long history and tradition of being able to make medical decisions for yourself with your doctor. The long history and tradition, you know, that phrase now is important. And so the fact that Armstrong was based on medical decision-making, I think, makes it that much stronger. In light of Roe. There are some weaknesses in Armstrong, and the Montana Supreme Court has already been asked by the governor and our current attorney general to overturn Armstrong. The court declined to do that just about a month ago because the case was on appeal from a case here from Billings, but its procedural posture, it was just on a preliminary injunction about whether a preliminary injunction should be granted or not. And the court said, we don't yet get to the merits of the case. So they declined to address Armstrong. But that case is back in Billings. It will go back to the the Montana Supreme Court. My guess is next year. And I don't think the Montana Supreme Court will be able to avoid the question. They're going to have to decide, do they overrule Armstrong or do they affirm it? Which is why who's on the Montana Supreme Court matters. So my conclusion here is that obviously there's no constitutional right to an abortion under the US Constitution anymore. There is still a constitutional right of privacy, but we don't know the extent of that. It may very well be trimmed in future years. Montana does have a constitutional right to an abortion per Armstrong and per our Constitution, but Armstrong could be overruled by a future Montana Supreme Court case. The right of privacy in the Montana Constitution is there unless we, the people, choose to change it. And if Republicans get a supermajority in our legislature next week, they have talked openly about proposing a change to our right of privacy in the Constitution. Different people want different things. Some want to change it to say it does not include a right to an abortion. Some people have said the whole right to privacy is stupid and should be taken out. On the other hand, if you have voted, and if you're about to vote, you know that you're being asked right now to vote on a constitutional amendment that would include electronic data in the kind of information that police have to get a warrant to search. That's privacy. So it's hard for me to believe this people of Montana would vote to just get rid altogether of our right of privacy. But it's entirely possible that Montana might vote to exclude abortion from that right. But the most immediate thing is the question: the Montana Supreme Court will face the question of Armstrong probably next year. And then the question of the Constitution, I guess, will also happen in our next legislative session. So that's where we are in Montana. Yes. So I'm not an expert on that. My understanding is that 2/3 of both the House and the Montana House and Senate have to vote to put a constitutional amendment on the ballot, and then we vote on it, but a simple majority wins. A simple majority of voters, people, citizens wins that. Yeah, so if there's a super majority in the legislature, that's just the first step. It will, any constitutional amendment has to be voted on by us. So